From there, down the N1 to the Western Cape High Court, where they've reserved judgment in the case brought by suspended Public Protector Busisiwe Mkhwebane. She's tried to challenge her suspension at the Supreme Court of Appeal. Our reporter Athi Mtongana joins us now. Athi, good afternoon. What news from there today?
Well, the news coming out of court today, in essence, Stephen, is that the Public Protector wants to further challenge the suspension by President Cyril Ramaphosa. Fundamentally, that's what we're dealing with here. You'll remember that it is the same court, the Western Cape High Court, that actually set aside the suspension by President Cyril Ramaphosa, whom the Public Protector argued that he suspended her based on retaliating on some of the complaints that she was investigating before her suspension, of course. And it's interesting today that we spoke to the Public Protector and I asked her whether or not she feels that the current investigation by her office, of course by the incumbent, the acting Public Protector, Advocate Galega, on Phala, is moving at a pace that is satisfactory. But she says she trusts the investigators that are working on the Phala matter and that she's satisfied that at least before she left office, she was able to send those questions to President Cyril Ramaphosa, who's currently a subject of investigation by the Office of the Public Protector, as well as Parliament in that independent panel. So today, Advocate Dalimpofu told the three justices that they want to actually take this matter to the Supreme Court of Appeal, where certain merits that they feel the three justices did not deal with will be dealt with there. They're also going to be arguing, if they do get leave to appeal to the Supreme Court of Appeal, that there are some classes of conduct that relate to the president that can actually be referred and confirmed by the Constitutional Court, and there are some classes of conduct that can actually or don't need to be confirmed by the Constitutional Court, as argued by the Democratic Alliance, which they say that this appeal by the Public Protector has no merit and it's impractical. The president's legal representative, Advocate Pillay, going as far as to say that this time around, in fact, in many instances where they've been in court, that the Public Protector is abusing court processes. I'd like us to listen to Advocate Bishop from the Democratic Alliance on what they are arguing before the Western Cape High Court.
This is the reason we'll have no practical effect is because Advocate Mkhwebane has received the benefit of a very urgent hearing in the Constitutional Court in a month from now. The Constitutional Court has set this matter down, the confirmation, appeal, cross-appeal proceedings, much more urgently than it normally would. And that is a benefit to Advocate Mkhwebane, because finally the legality of a suspension or otherwise will be determined as soon as possible. Rightly so, the DA has no objection to an urgent determination of that. But the question is, what is the consequence of that fact for this application for leave to appeal against the refusal of interim enforcement relief? And I just want to make 2 points about it. First, what is the likely timeline for this application for leave to appeal, if it's granted, for the appeal, if it is granted? And secondly, what does that mean when it's in relation to the court proceedings? I've set out, my lords, in detail in the heads of argument the likely timeline and refer this court to other cases, Section 18.4 cases, which, as Mr. Mpofu pointed out, have to be heard as matters of extreme urgency. And in those cases, we know that the SCA, the fastest it is likely to get from an order of this court to a judgment is about 60 days. That's the quickest that it's acted. It's gone up to over 100 days in the dispute between the city of Tshwane and the Premier of Gauteng. And so, making several assumptions in favor of Advocate Mkhwebane, that this court gives its judgment today, that the SCA decides to treat this appeal as one of extreme urgency, even though it is not covered by Section 18.4.
Well, that's the latest from the courtroom. Athi Mtongana in Cape Town. Thank you very much indeed. Well,